Very much, Mr. Chairman. Mr. Chairman, I actually have to start out, I think, here with an apology, and that is to Charlie Griffin. When I welcomed Mr. Griffin, I welcomed his wife and his daughter. Charlie, I did not know you were here. So you are very welcome here, and we're very pleased you're here. I hope you're enjoying this. I will add, though, into this, I am very concerned when senators use procedural technicalities or filibusters to block any nominations to the NLRB. This is not based on any substantive problem with the nominees, but on fundamental hostility to the work of the board. Like the Consumer Agency, the Environmental Protection Agency, and the Department of Labor, the NLRB is an agency of the federal government that was created by Congress. Its existence is part of our federal law, and yet the NLRB nominees face the same problems that Rich Cordry has faced at the Consumer Agency, that Gina McCarthy faces at the Environmental Protection Agency, and that Tom Perez faces at the Department of Labor. This is about complete obstructionism because a minority of senators don't like the agencies and they don't like the work these agencies do. In my view, this kind of obstructionism is a violation of the Senate's fundamental constitutional role to advise and consent on nominations. By all means, senators can vote against nominees with whom they disagree, but these nominees deserve a vote, and I hope they get a vote. And I think that's what this is about today. I also want to make it clear, we've heard from 5 qualified individuals who will be voted on as a package. I certainly don't agree with the views of all 5 of the individuals. I find it very troubling, for example, that one of the nominees was hired by the Chamber of Commerce specifically to curb the NLRB's regulatory authority. But this is not about whether I agree or any of us agree with the individual views of the ideology of each nominee. This is about whether or not the NLRB can function at all. It is about giving both workers and employers a fair chance to have their voices heard and their disputes resolved. That's what we're here today to move forward, and I will support a package of 5 nominees. Now, I have a couple of questions, but one of them comes from what Senator Scott raised. He seemed to imply that the NLRB is working hard to make sure that all employees in America are not courteous. And I surely think that cannot be the case, so I've tried to find out what I can about the case in particular that he talked about. And there are 2 parts to it that interested me. The first is that I understand that the Carl Now's Motors case is the one we're talking about here, is a case where the employee used social media that affected the employer, complained about his or her job, and in that case, the NLRB ruled that the company could terminate the employee for derogatory comments about the company. Is that correct?
Yeah, I'd like to clear a couple of things up. First of all, if I can say a little bit about that courtesy rule. We don't have an issue with courtesy. We had an issue with the sentence that said prohibiting saying anything unfavorable about the employer was the problem. Consequently, that rule had to be dealt with because of that vagueness. Now, Carl Knauss, with respect to the social media piece, you had 2 postings. One posting was by the salesman of a video of the son of a customer, 13-year-old son of a customer, jumping into the car that the customer had just test drove, running over his father's foot and crashing the car into a pond at the dealership. And the posting was, whoops. The other posting was, this was a BMW dealership, and they were having a promotional celebration, and they were offering water and hot dogs. And that posting was, what kind of low rent outfit is this? Words to this effect. We're trying to sell fancy cars, and this is what they're offering to the customers. Now, the first posting involving the accident was the posting that was the basis for which the employer terminated the employee. We concluded that that was not protected activity. That was done on an individual basis as a lark. It was kind of snarky. It had nothing to do with terms and conditions of employment. Consequently, we found there was no violation. With respect to the hot dogs...
Sorry, let me just make sure for all of us who don't do labor law all the time, it means the employer could fire the employee for that posting. Thank you.
And the other one about the hot dogs, we reserved on it because it wasn't in front of us.
Okay, good. I just wanted to be clear about what's happening to the American workplace. Thank you. Mr. Chairman, I see I'm out of time. I'll submit questions for the record. Thank you all very much, and I do want to say again, I know this is tough to take on public service like this, particularly now, and particularly when there are much larger debates that go on that are not having to do with you specifically. I'm grateful to all of you for your willingness to serve, and I have no doubt that all 5 of you would serve the NLRB and serve this country well.